Regulatory taking is a situation in which a government regulation limits the uses of private property to such a degree that the regulation effectively deprives the property owners of economically reasonable use or value of their property to such an extent that it deprives them of utility or value of that property, even though the regulation does not formally divest them of title to it. United States law. In common law jurisdictions, state governments traditionally enjoy police power, under which a government may regulate a variety of aspects of the lives of its subjects. Under American law, however, this power does not extend to the outright divestiture of title to private property, nor to the de facto equivalent of it. Instead, the power of eminent domain is a separate and distinct power which allows a government to divest a property owner of utility of such property. But when it does so, it must pay just compensation. Some states, not the federal government, use the full compensation standard, not the just compensation standard. This power is limited in the Fifth Amendment to the United States Constitution, and extends to the states under the Due Process Clause of the 14th Amendment. This prohibition is deemed incorporated in the Due Process Clause of the 14th Amendment. Physical occupation. The most straightforward takings claim arises when the government physically occupies some part of a landowner's property without compensation. This runs directly into the plain language of the amendment itself. It is a taking of some property without compensation. With certain exceptions, a direct physical occupation, temporary or permanent, represents a taking. In some few cases, we find disputes surrounding whether a government action in fact constitutes a physical direct and immediate occupation of land. A leading case is United States v. Cosby, 328 U.S. 256, in which a landowner was subjected incessant low-level military flights well below the federally recognized aviation airspace. In requiring compensation, the court held, the landowner owns at least as much of the space above the ground as they can occupy or use in connection with the land. See Hinman v. Pacific Air Transport, 9 Circle, 84 F2D 755. The fact that he does not occupy it in a physical sense by the erection of buildings and the like is not material. In this case, as in Portsmouth Harbor Land and Hotel Co. v. United States, Supra, the damages were not merely consequential, they were the product of a direct invasion of respondent's domain. As stated in United States v. Kress, 243 U.S. 316, 328, 37 S. Court, 380, 385. It is the character of the invasion, not the amount of damage resulting from it, so long as the damage is substantial, that determines the question whether it is a taking. Flights over private land are not a taking, unless they are solo and so frequent as to be a direct and immediate interference with the enjoyment and use of the land. Regulatory restriction on use of property. In contrast, a regulation restricting the use of property to further legitimate public ends will not be considered a taking merely because it impairs the value or the utility of that land. However, when the regulation goes too far, it will be judicially recognized as the equivalent of a taking, which may not take place without payment of just compensation to the property's owner. The issue of regulatory takings arises from the interaction between exercise of the traditional police power and exercise of eminent domain. The police power is the inherent state government power to do what is reasonably necessary to promote and protect public health, safety, welfare and morals. There are numerous instances where the U.S. Supreme Court has found that state courts have reasonably concluded that the health, safety, morals, or general welfare would be promoted by prohibiting particular contemplated uses of land. And in this context, the Supreme Court has repeatedly upheld land use regulations that adversely affected recognized real property interests. Zoning laws are the classic example. See Hadachek v. Sebastian, 239 U.S. 394, Village of Euclid, Ohio v. Ambler Realty Co., 272 U.S. 365, Goreb v. Fox, 274 U.S. 603, 608, Welch v. Swazi, 214 U.S. 91, which have been viewed as permissible governmental action even when prohibiting the most beneficial use of the property. However, zoning restrictions may deny an owner any economically viable use of his land. Suppose a low-density residential zone requires that a house have a setback of no less than 100 feet. If a particular property were only 100 feet deep, it would be impossible to build a house on the property. Governmental land use regulation that deny the property owner any economically viable use are deemed a taking of the affected property. See, e.g., Lucas v. South Carolina Coastal Council, 505 U.S. 1003, First English Evangelical Lutheran Church v. County of Los Angeles. The general approach to this question was summed up in Agans v. City of Tiburon, 447 U.S. 255, which states that the application of land use regulations to a particular piece of property is a taking only if the ordinance does not substantially advance legitimate state interests, or denies an owner economically viable use of his land. However, in Lingle v. Chevron, 544 U.S. 528, the Supreme Court overruled the substantially advance criterion of a taking. When a government regulation affects the taking of private property by such excessive regulation, the owner may initiate inverse condemnation proceedings to recover the just compensation for the taking of his or her property, provided that procedural hurdles have been overcome. In recent years, the concept of regulatory taking has been used more loosely, outside the constitutional sense, by property rights groups, extending to include regulations that reduce property values by lesser amounts. Ballot initiatives based on this interpretation have been advanced in at least 7 states in the years 2000 to 2006. All these states are in the American West, but a significant portion of the funding for the initiatives has come from sources on the East Coast. Inverse condemnation. Inverse condemnation is a term which describes a claim brought against the government in which a property owner seeks compensation for a taking of his property under the Fifth Amendment. In states that prohibit uncompensated taking or damaging physical damage to property is included in this definition. The term inverse is used because usually condemnations are brought by the government. In the inverse condemnation context, it is the property owner who sues the government, alleging a taking of property without just compensation. See San Diego Gas and Electric Co. v. City of San Diego, 450 U.S. 621, 638 N. 2, United States v. Clark, 445 U.S. 253, 257, Agans v. City of Tiburon, 447 U.S. 255, 258 N. 2.